Well, I heard the 6 bells. If everybody's here, I guess we'll go ahead and get started. Let's call this meeting of the Board of Zoning Appeals, special work session meeting for the Board of Zoning Appeals of the City of Westminster. Happy St. Patty's Day to everybody. First order of business, the approval of the minutes of our last hearing. Has everyone on the board had a chance to review?
I have.
If so, do we have any changes?
Not to me.
I have one if you don't. I think the second to last paragraph, the bottom of page 3, that section should be 164-161. It's just reversed. Am I correct in that?
164, 161, yeah.
Yep.
And that was the only thing that I caught. Other than that, do I have a motion to approve with that change?
So moved.
A second?
Second.
In favor? Aye.
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 So passed with that change. Second order of business would normally be a regular public hearing, but we have none. So with other business on the agenda for this session, this is a Board of Zoning Appeals work session. Board Staff Liaison Gray will brief the board on current application process and the basics of planning and zoning, followed by Board Attorney Ruff, who will brief the board on processes and standards of practice utilized throughout the state of Maryland and for the education of the board, as required by section 1-206 of the land use article. The board may discuss process moving forward. No cases shall be heard or deliberated upon during this work session. So given the order of business here, I guess we'll turn this over to Mr. Gray to initiate our meeting.
Thank you, Mr. Chair. Good evening. For tonight's presentation, I will be providing a brief introduction of planning and zoning and the current BZA application process. I'll be followed by Board Attorney Ruff, who will go over board processes utilized throughout the state of Maryland and standards of practice utilized throughout the state of Maryland. Staff understands you all are well aware of most of this information. However, members of the public listening may not be, and this is a good foundation for anyone listening to hear. As mentioned in the report, staff requests that any question from the BZA be general in nature and limited to the presentation and any procedural changes. Should there be any questions regarding past or future cases, staff recommends the Board of Zoning Appeals vote to hold a closed session following the presentation. For my first slide, just to give you a brief background on the United States Constitution, the Fifth Amendment, government takings are prohibited, i.e., nor shall private property be taken by the government without just compensation. The 10th Amendment, powers not delegated by federal government are reserved to the states or to the people. More specific to Westminster, zoning belongs to the state in the form of the police power, and the state of Maryland delegates that power to its local governments, i.e. the city of Westminster, Carroll County, Baltimore County, etc. Remember, counties and municipalities are children of the state, or there is only one sovereign entity in Maryland, and that is Maryland. The 14th Amendment mentions, nor shall any state deny to any person within its jurisdiction the equal protection of the laws. I would like to note the fundamental planning legislations that I learned in graduate school. And these were, I don't have this on the slide, but the Standard State Zoning Enabling Act, which mentions that a legislative body like the Mayor and Common Council of Westminster can divide the jurisdiction into zoning districts, and the Standard City Zoning Enabling Act, which mentions about the organization and power of a planning commission and the content of a master plan. This would be covered now in Maryland state law. to the United States Supreme Court, just to give a couple quick background court cases which are important to zoning, is Euclid versus Ambler Realty Company in 1926, which found that zoning is a valid use of the police power. In the Nolan case, there must be a rational nexus between any exaction from the government. This is important to note since the board cannot include a condition that does not have a legitimate connection with the project. In the Lucas case, a taking occurs when regulation denies a landowner of all economically viable use of land. The Doolin case, there must be a rough proportionality in nature and degree between the impacts of a proposed development and the impact-related exactions imposed as a condition of approval. And lastly, just to put this in there, since it was a very recent case, the Reed versus Town of Gilbert, Arizona case, which talks about content neutrality of sign ordinances. What is planning? Planning sets a course of action for the development of land based upon a community's vision for the future. The City of Westminster's comprehensive plan sets out the vision for the city's future through goals and objectives adopted by the mayor and common council. There are several tools available to a local government to implement the comprehensive plan, one of them being zoning. And what is zoning? Zoning is, in the basic sense, zoning implements planning. In the city of Westminster, the mayor and common council adopt a zoning ordinance and a zoning map to implement the comprehensive plan and guide development uniformly and fairly across the city. These rules are put into place during a public process for a purpose, and they must be followed and enforced. Planning documents are implemented through local ordinances and resolutions. Zoning ordinances establish regulations for the use of land and standards for development within identified zoning boundaries. The zoning map identifies properties that fall within different zoning categories. And just one more quick point, the mayor and common council makes the final decision regarding zoning. For Westminster Board of Zoning Appeals, this body gets its power from the city zoning ordinance, which is derived from section 4301 of the land use article of the annotated code of Maryland. The powers of the Board of Zoning Appeals consist of appeals from an administrative official, special exceptions, variances, and also I would like to note, in addition to these powers, in section 164, 136B provides power for the board to grant a change in non-conforming uses. And as some of you may remember, this happened about 3 years ago. We had a case on that on West Main Street. The Board of Zoning Appeals process, when an application is received, staff receives that application. We prepare legal notices. Notice goes in the Carroll County Times, 2 notices. The property gets posted, an agenda gets uploaded on the city website, and adjacent property owners get notified with certified mailing. The applicant then provides a pre-hearing statement, and then planning staff prepares the staff memo. This staff memo then and other pertinent information is sent to you all and the applicant. Then this body hears the case, and then a written decision is forwarded to the applicant. That is all that I have. I would just like to just say one more thing. On page 12 of 13 of your packet, I have included information that I send to applicants who inquire about any one of the board's processes. just to wrap up my discussion, I always think of the Board of Zoning Appeals as judges. 3 judges deciding on a matter to uphold the integrity of the city zoning ordinance. You analyze the zoning law that was passed by the elective legislative body of this city, and you make sure it is upheld fairly for its citizens. Ms. Ruff will now get into more details about BZA power and duties. Thank you all.
Anybody have any questions for Andrew first? Okay.
All right. Well, good evening, everybody. I would like to start by backing up just a tad to say that the General Assembly in 2009 adopted legislation that required planning boards and boards of appeals to do a training related to their powers and the planning and zoning process. And that is really one of the reasons that we're here tonight. And I would like to say that my presentation focuses on Module 7 of the training program. If anybody has taken the planning class, it's on the planning.maryland.gov site. If you were to go to Module 7, you'll see that that's really, in essence, what we're going to talk about tonight. So can I ask, has everybody on the board taken that class so far?
Way back when for me.
Way back when.
I've taken it a couple times at this point, I believe.
Yeah, I've taken it at least once.
Okay. So what you're going to hear tonight then is really going to be a repetition of what you learned. But if you have any questions, please feel free to ask. So as Andrew had said, planning sets a course of action for the development of land and is based on a community's vision for their future. And the planning documents are implemented through the local zoning ordinances, which establish regulations for the use of land and standards for the development that are identified within each of the zoning district boundaries. And the zoning map will identify the properties that are in each of the different zoning categories. And the legislative body is the one that makes the decision regarding zoning. So if you turn to the Annotated Code of Maryland, which is where the municipal corporations get their power to create the zoning and land development regulations. If you look at the land use article, the statement of policy is that the orderly development and use of land and structures requires a comprehensive regulation through zoning and planning controls, and that those are implemented by the local government. Now, the general power to do that is through the health, safety, and welfare of the community. It is through that power that local governments have that a legislative body of a municipality can regulate. It's the height, number of stories, size of buildings and structures, the percentage of a lot that may be occupied, off-street parking, the size of yards, courts, other open spaces, population density, and the location and use of buildings, signs, structures, and land. Then the legislative body can adopt zoning regulations in accordance with the plans that is adopted, with consideration given to various things, including the character of the zoning district and its suitability for particular uses, with a view to conserving the value of property and encouraging the orderly development and most appropriate use of the land that's there. The zoning regulations are generally designed to control street congestion, promote the health, public safety, and general welfare, provide adequate light and air, promote the conservation of natural resources, prevent environmental pollution, properly manage growth and development, and promote or facilitate adequate transportation, water, sewer, schools, recreation parks, and other public facilities. So then we get to variances, because when you enact legislation that impacts a wide variety of properties, the application of that law to every property may have a different impact. So variances have been recognized as allowable to address the negative or disproportionate impact that a regulation may have on a particular property. So the modification in a variance can only modify density, bulk, dimensional, or area requirements of the zoning law. May be only allowed where owing to conditions peculiar to the property and not because of any action taken by the applicant, a literal enforcement of the zoning law would result in unnecessary hardship or practical difficulty as specified in the zoning law and may not be contrary to the public interest. Now that's in the land use article, section 4-206, and that is outlined in the information that was provided to you tonight. Now, under section 4301 of the land use article, the legislative bodies are required to appoint a board of appeals, and the board of appeals is required to adopt rules in accordance with the local law to address its operations. And you have your rules of procedures that were adopted, I think it was in 2009. And so that may, if it's not something you've taken a look at recently, we might want to take a look at the rules of procedure and see if there's anything that you would like to modify or change. Otherwise, we can continue with them in force as written. So member of the Board of Appeals, and this is in section 4304 again of the land use article, a member of a Board of Appeals is required to recuse themselves from participating in a matter in which the member may have a conflict of interest or an appearance of a conflict of interest. And a Board of Appeals is required to keep a recording or transcript of their proceedings. It shows the vote of each member on each question, or a member's absence or their failure to vote on the particular issue.
Karen,
Yes.
can you speak a little bit more, because I've dealt with a lot just for the benefit of all of us, regarding recusal? Because when you live in a small town like we all do,
Mm-hmm.
you know, like, for instance, in my, profession, I know a lot of people. And, having talked to the county attorney, when, I've been on planning and zoning for Carroll County, me knowing somebody or having some sort of a moderate social relationship with them or some kind of past transaction is not necessarily cause for recusal. It can kind of become in a gray area. Obviously, if I have a current transaction with them, it's a problem. Or if they are, to a certain degree, a close personal relationship, then yes, I got to recuse myself. But it's kind of hard sometimes in a small town like this to kind of figure out, where that boundary is. And if you could expand on that, because I think it's beneficial for us all to know that more clearly of when should we recuse ourselves? When shouldn't we? Can you address that a little bit?
Well, I think that the rule of thumb is if you do not think you can be impartial in exercising your judgment in a case, you're required to recuse yourself. If the nature of that relationship is such that you feel I couldn't possibly rule against them, or they couldn't possibly ask for something that they're not entitled to. That might be overstating it a little bit, but the recusal, oftentimes what you'll see before a Board of Appeals is somebody will disclose and say, okay, so the applicant before us today is, and identify the relationship, lives in the same development I do, is a friend of a friend. I met them at, parties in the past, but despite my knowing who they are, having spoken to them in the past, I still believe I can be fair and impartial in judging the case. So sometimes it's a matter of just putting it out there. If it's a family member or a close personal friend, I think that the better course of action is to recuse yourself, because sometimes, ethical things it's how things look.
Correct.
The appearance of impropriety, as they say. So, without knowing the specifics of a particular case, it's kind of hard to say exactly under what circumstances I would recuse myself or or
Well,
not?
I think what we all need to keep in mind as a board when we're functioning in this capacity, particularly more so on BZA than on a planning and zoning situation, because we're always in a quasi judicial role in a BZA function, is that if any of us have any concerns on a particular case, we should definitely reach out and discuss the nature of that relationship with you, before we make a decision. Because what my point is, it can be kind of like, sometimes I have to think things through myself. And admittedly, because of my role on planning and zoning, I've had a lot more opportunities to sit there and have to think, okay, is this a problem or is it not a problem? But I think it's important that you always have to think that through and, as you say, disclose it and then state whether you feel you can be impartial or not.
Well, and as you stated, if anybody on this board ever had an issue that they wanted to discuss as to whether their relationship with any particular applicant would cause them to be in the situation to recuse themselves, they can always call me and we can talk it through and discuss, the nature of their relationship and how that might or might not impact their sitting on the hearing on the matter.
Okay.
Does that make sense?
Yes. Yeah. I just thought it was worthy of some discussion because I think it's so, I think there are certain times where, you need to recuse yourself, as you said, either because you feel like you cannot be impartial or really it just doesn't look right. But it's not, when you're in a small town like we are, everybody sort of knows everybody to a certain point. When someone
Right.
files an application, you recognize their name or somebody who knows them or, so, it's
And
not
that's not always going to be a situation that's going to require you to recuse yourself.
correct. Yeah, that's what my point is. Okay.
Sure. So the powers of a Board of Appeals under the land use article is to hear and decide appeals when it's alleged there's an error in an order or requirement, decision, or determination of the administrative officer, which is what Mr. Gray had referenced earlier. To hear and decide special exceptions to the terms of the local law, and to authorize an on appeal in specific cases of variance from the local law. And
Aaron, can I
then,
ask a question there?
yes, sir.
To the, and I don't want to start nitpicking right away, but I think it's important, and this is a good time to kind of air it out. Error in any order, requirement, decision, or determination made by an administrative officer. Can we talk to what constitutes an error? Because, just that word in and of itself, from my perspective, could lead to lots of different interpretations. So somebody believes that an error has been made, it would seem to be that has to be specifically cited when somebody makes an appeal. Very specifically cited.
So I am going to ask the planning staff if they can give us an example of a situation in which an administrative appeal would be filed, challenging what type of decision, and then we can go from there.
Good, super.
I guess I'll take that one. So what we do offer are interpretations or determinations of the zoning ordinance itself.
Right.
So if a use is listed in the ordinance that isn't defined and somebody wants some definition or explanation as to what that use is, we could provide a determination as to what we believe that definition of that use is, or a section of the ordinance that may seem unclear. Somebody can ask for an interpretation and determination of that section of that ordinance. And so we would do an official determination through a letter, and anybody has 30 days to appeal that decision, essentially stating that they believe that the interpretation of staff, or this case, the zoning administrator, is not correct, and bring it before the Board of Zoning Appeals as to whether they believe the zoning administrator was accurate in their interpretation or if the applicant's interpretation is the proper one.
So the error in that situation would be the planning staff's interpretation. The board would take a look at what their letter said. They would hear from the person appealing the decision, and then the Board of Zoning Appeals would be in a position to determine whether an error was made in that interpretation, whether it should have been interpreted differently.
Okay.
Now, and Karen, I'm not sure if, I'm not too familiar with the site plan process, but if the planning commission makes the decision and approves a site plan, and that decision, can that decision be appealed to the Board of Zoning Appeals because somebody believes that the site plan was approved in error and does not meet the requirements of the zoning ordinance?
I'd have to look that up specifically, Mark.
I'm not sure. I'm not sure if the Board of Zoning Appeals deals with that or not.
I was going to say, I don't know that they do with the site plans, but I'd have to look that up specifically. I don't know.
Yeah, that may bypass the Board of Zoning Appeals. But typically,
Can't that be based off of how your particular code is written too? I would think.
yes.
Yeah.
But the ones that I think we'll typically see, or any appeal, would be to that official decision or determination made by the zoning administrator.
I mean, that's the type of situation that I have been most familiar with being appealed to the boards. But I'll tell you what, a little bit later when I have a moment, I'll check the code real quick and see if I can get the answer about the site plan.
Sorry about that, Karen.
Yeah, quite all right.
Well, I think that's a good point that Mark brings up, because I can recall in a general sense, there have been a couple of cases, let's just say that way, where during discussions, there have been some questions about site plans and whether or not something was accurately recorded or discovered that something was slightly, not aligned or whatever. But, yeah, it'd be good to get clarity on that too, because sometimes we do see site plans.
Okay. All right. So if we go back to the land use article and take a look, we just talked about the powers and what the Board of Appeals can hear. And when you look at 4306 regarding appeals and procedures, appeal to the Board of Appeals can be filed by a person who's aggrieved by a decision of the administrative officer, or an officer or unit of the jurisdiction that's affected by the decision of the administrative officer. A person has to file the appeal within a reasonable period of time in accordance with your rules of procedure. And an appeal to the board will stay all proceedings in furtherance of the action that's being appealed. And a Board of Appeals has to establish a reasonable time for the hearing of the appeal and give public notice and have a hearing conducted in open session. Let's see. And then when making its decision in those appeal cases, they could wholly or partly reverse the order, the requirement, or decision that's being appealed. They could affirm the order in whole or in part. They could modify the order, or they could issue an entirely new decision. The board would have all of the same powers that the administrative officer had in taking its action at the time that it made its determination. So now if you look at the local government article of the annotated code, also talks about how a municipality may adopt zoning regulations subject to the right of referendum of voters. So in addition to what we have in the land use article, we also have some further authority under the local government article. So now if we move to variances, so the applicant can request a variance from the development standards that are in the city's zoning ordinance. And if a variance is necessary, it's the applicant's burden to put forth the information that is required to support their application and to present that to the board. And then the board will make its decision based on the evidence presented to it at the hearing. The Maryland courts have defined conditions under which a variance may be granted. And a variance may be granted for cases where the applicant faces a hardship due to features or circumstances that are unique and not generally shared by other properties in the same zoning district. Now, the unique circumstances must not be self-created or self-imposed by the applicant, and the granting of the variances must not confer any special privilege that would be denied to other property owners in the same district. And it has to be the minimum relief that's needed. So when you look at all of that together, an issue that comes up frequently for boards of appeals is whether a variance is necessarily granted is going to create a precedent that the board would have to follow in the future. But given what variances are and that they're unique to the property, in order for it to establish a precedent, you'd have to have, identical circumstances with respect to the property itself and the hardship that was created. So variances do not establish a precedent for the next way you'll act on a variance, because it's highly unlikely that the situations are going to be identical. Then
I will own up to misusing that word precedence in a past case.
well, you're not the only one. I mean, it comes up frequently with boards of appeals. Concerned that if, we grant this situation, is that going to require us to make the same decision into the future? And so I think what you have to just keep in mind is, unless you have identical circumstances, it's not going to set a precedent for you to act into the future on the same type of request.
Right.
So those are variances. And then the next set of powers and duties is approval or consideration of special exceptions. And zoning categories include uses that are permitted by right and uses that are permitted by special exception. And a special exception is a land use that's permitted subject to specific conditions in the ordinance. And that makes it possible to allow uses where they are reasonable, but deny them where the specific conditions in the ordinance cannot be met. So the Board of Appeals, again, would make the final decision on the special exceptions as well. So then if you move into the roles and responsibilities of the Board of Appeals as outlined in the land use article, a Board of Appeals consists of at least 3 members. The terms of office of the board are 3 years. A member of the board is appointed by the local executive and confirmed by the local legislative body. The jurisdiction of the board is set forth in section 4305 of the land use article, which we already went over, so I don't think we need to revisit that. But a Board of Appeals acts in a quasi-judicial capacity when it hears cases, and those cases can be appealed to the circuit court. So all witnesses testifying before the Board of Appeals should testify under oath. All of the proceedings of the board are recorded. I'm sorry, I lost my place. The record of the board's proceeding is important in an appeal to the circuit court because the court makes its decision based on the record. They don't hear it de novo. We'll get into that a little bit later. I had provided you with 2 cases, not necessarily to read them all, but there are certain provisions I'd like to focus on in a little bit that might provide you with some assistance when you're thinking about how we articulate our decisions, because it'll show what the court's looking for if it ever goes up on appeal. So we already touched on this before, that the hearings of the boards of appeal are subject to the Maryland Open Meetings Act, and a person can testify at the board hearing if they're a witness. The public doesn't necessarily have the right to participate. That's up to the board. Like any other public body, the board can conduct a closed session, but it has to be for one of the articulated purposes in the Open Meetings Act. And the most popular one is to seek legal advice on the proper standard to apply in a given case.
Hey, Karen, in that regard,
Yes.
it's kind of been common practice whenever an applicant has support, if you will, well, for that matter, even those who may not be in support, when people come in, the public comes in, they're asked to sign in and to say if they want to be heard. Are we prematurely asking that, or what's your comments on that?
Well, I think that the point is that since it's a quasi judicial proceeding, that you are not required to hear from everybody. But I do know that boards of appeals generally will hear from those for and against, and that's in your rules of procedure. Your rules of procedure provide for that testimony from the government. I have to go back to it, but then it's the applicant, and then it talks about hearing from people in opposition. So that might be something we want to pursue and make sure that you want to retain the language as it is in the rules.
Okay, thank you.
Mhm. So, and then the board has to deliberate in open session when it talks about how it's going to act and what it's going to do in a particular case. So, and then if a party is not satisfied with the decision of the board, it can appeal that decision. And because of the quasi-judicial nature of the proceedings that are before the board, the board members should not engage in ex parte communications with applicants that come before it. So, and then at the end of a case, when the opinion is prepared, it has to have the board's decision and the reasoning behind it. So it's important that it outline the factual basis for the decision so that the circuit court can properly evaluate it. So that's like the parameters of the state law. That's what the land use article says. I guess I shouldn't speak with my hands. I'm sorry about that. But based upon that, then the city of Westminster adopted its zoning requirements. And we can talk about that a little bit if you'd like. But it subsumed in that is your Board of Zoning Appeals and the provisions that apply to the board. And then the board has taken its authority to create its own rules of procedure. And we already talked about the setting a precedent. So if you were to kind of glance through the city's Article 22, where the Board of Zoning Appeals is, it will reiterate much of what we already went through with state law, but it will then say in a slightly different manner the powers and duties for consideration of variances, but it touches on everything. It touches on your meetings being open, how the appeals are handled, the stay of the proceedings as we discussed, your special exception standards, and it goes through how you have to have a public hearing and how public notice is given, and if you have a postponement or continuance, how that is handled as well. So in addition to the information we just went over, I had circulated a case, Montgomery County versus Rotwine, to show you two things primarily. One is when you look at what the court says their role is in reviewing an appeal of a Board of Zoning Appeals decision, it's the substantial evidence test. And the test requires the court to affirm an agency decision if, after reviewing the evidence in a light most favorable to the agency, they find a reasoning mind reasonably could have reached the factual conclusion that the agency did reach. They can't substitute their judgment for that of the board unless the agency's conclusions were not supported by substantial evidence or were premised on an error of law. So that is why when you get to after your discussions about the case and when you're deliberating on it, it's important to at least touch base on the criteria for approval of a variance or a special exception so that we can make sure to include in the decision clearly how you came to that decision so that if it were ever appealed, we would be able to show the court that we shouldn't be overturned. Does that make sense?
Yes.
Anybody have any questions about
Both to
that?
me.
Because I know at the last meeting, I didn't mean to interrupt, but I wanted to make sure we did kind of touch base on each of those items. And then the thing that I thought was interesting about this case as well is where the court talked about the fact that just because the applicant wanted to put the garage in a particular location, that did not constitute sufficient reason to grant the variance. That they could have put the garage in another location that met the setback requirements. So it wasn't enough that it was just desirable and could do no harm where they were proposing it. That didn't meet the standards for approval. And the last
So
thing
Karen,
that,
when you, sorry, when you say that, so when you're grading, a lot of times, like, I feel like when somebody might come to you for a variance, it's because, you know, they might feel that the location of their deck or the size of what they want to build is more desirable because of X, Y, or Z. And they might have a very valid reason for that, that quite frankly, we might agree with. So is that okay or not, from what you're saying?
it depends on the facts of the individual case. So if you have, let's say all things being equal, somebody wants to put a deck on the east side of the property, whereas if they put it on the west side of the property, they meet the setbacks, right? So if they can put it on the west side of the house instead of the east side of the house and meet the setbacks, that's really what they should be. That's really what they should do, right? But you're going to have situations where maybe there's no way to get out of the house on that side of the house. You know, so it depends on the situation. But it also, think about, it's supposed to be the minimum necessary. So if somebody comes in and they want a 20 by 30 deck, and that creates the need for a variance of 5 feet, let's say, then maybe they need to reduce the size of the deck to meet the setback requirement. Because they may want 20 by 30, but maybe they can, you know, a 20 by 30 will do it just as well.
So it sounds like we're in a little bit of a gray zone in the sense of how, you know, what is too far or what isn't to a certain point. I feel like, I mean, I know you don't like to say gray zone, but it feels that way because the reality is it kind of depends upon the nature of the request and the reasoning for their requests. But if someone's just simply coming in and saying, I want my deck here because that's what I want, that's not necessarily a good enough reason. There has to be a logic to why they want that. And it can't just be because they want it.
Right. And I would say you should read this Montgomery County case because I think it is really good about getting into that analysis, you know, because the lady came in and she said, I'd like to put it here. And the court basically said, but you could put it over here and meet the requirements. And she said, yeah, but I want it over here. And the court said, yeah, but you can put it over here. And then they got into a discussion about economic costs, you know, in doing it. So I think that I included this case because I think it is a really good discussion about how you kind of have to weigh the different factors that come before you
Okay,
when
well,
you're talking about
thank
it.
you for including that. Well, then I will read that in depth because it sounds like an interesting.
Yeah, I did read it in depth, and I'm glad you brought this up, Dan. I was going to bring it up anyway. I mean, reading a case history like this, if that's the proper term for it, really provides insight in terms of how a decision we make is going to be looked at if it's taken to the next level.
Mhm.
And what I find, to Dan's point, that maybe creates this, at least from a practical thinking point of view, some gray areas, is the continuing use of reference to unique, unusual, or different, that the aspects or characteristics of the property
Mhm.
in relation to whether or not it is a consideration of practical difficulty or unreasonable hardship. And that's where an applicant really needs to work hard at coming up against our code and being the least intrusive, if at all possible. And to the extent that, Karen, I don't think you ever need to excuse, that's why you're here working with us, to come in on the last case to bring up just that consideration about making sure we are going down all the list of the criteria in our decision against which this thing is being weighed, that being the code. And outlining each one of those things, because you get to that point where now you are really talking about whether or not the applicant has proven unreasonable hardship. And then another little conjunctive phrase that jumped out at me, that I want to come back to as well, is where you put a little or in between. Let me find that real quick, because I want to use it as a reference, and it was actually in your other case study. And an annotation was made that brought it to mind that for me, determination of, let me read at least a whole sentence so it kind of puts it into context. The supportable finding of uniqueness or unusualness, that's the first step. Second step is taken in the process, i.e. a determination of whether practical difficulty and/or unreasonable hardship results in a disproportionate way, impacting on the ordinance that caused the property's uniqueness. And they call that a disjunctive, where you have that and or in there, especially the or part. Can you talk to that a little bit? I hope I just haven't thrown a whole bunch of stuff out there that's confusing, but that to me kind of caught me when I read in detail and outlined and highlighted these two cases that you sent.
So the courts, as far back as Cromwell versus Ward back in 1995, which is one of the cases that you hear referred to a lot when you're talking about variances and things like that, established basically what's referred to as a two-step analysis when you're looking at variances. And
Right.
in that, the court said that the first step requires a finding that the property where the structure is to be placed is in and of itself unique and unusual in a manner different from the nature of surrounding properties, such that the uniqueness and peculiarity of the property it's the property that's causing the zoning provision to impact the property disproportionately. Okay. So it's not really the circumstances of an individual necessarily. You're looking at the property and the application of the zoning to it. Now, keep in mind too, that if one particular property is impacted, but so is another one and another one and another one, the better course of action is amending the zoning ordinance to address the issue. Not to continue to grant variances, right? So it would be an amendment to your zoning regulations that would address the fact that this issue continues to come up with this area or where these properties are located. So then it goes on to say that unless there's a finding that the property is unique, unusual, or different, the process stops there and the variance is denied.
Right.
Without any consideration of practical difficulty or unreasonable hardship. However, if the first step results in a supportable finding of uniqueness and unusualness, or unusualness, then the next step is a determination of whether practical difficulty and or unreasonable hardship results from the disproportionate impact of the ordinance caused by the property's uniqueness. And that is something that the courts have continued to rely upon, that two-step analysis. So, it's kind of funny. When you talk about this, you continue to hear the same words and analysis repeated over again. It's almost like defining something by using the word. And so I guess the one thing I would say too is that when you're dealing with area variances, which are variances from, height, density, setback, side restrictions, those are the types of things that, and I want to make sure that I get this right. Because the changes to the character of the neighborhood are considered less drastic when you're doing area variances opposed to a use variance, which is how you can use a piece of property, the courts have applied the less stringent practical difficulty standard to area variances.
Karen, you bring up area variances. Let me just jump into something to get your take on something that I think is something that we deal with a lot on BZA, or just the nature of Westminster. I live downtown, and so I think the zoning in my particular street is R7500. Okay, and but if I was in a new subdivision of R7500, the setbacks, like my house is like practically right on the street because I'm downtown. Where if I was building a new subdivision, my setback would be, whatever that is, 40 feet or whatever it is in R7500. So if I'm downtown and I'm like tearing down my garage, or let's say my house burned down, Lord forbid, and I'm building a new house, it would look very odd for me to build a new house 25 feet back, or whatever the setback is from the front of the street, because that's not how anybody else's house is, because I'm downtown. And everybody else around me, or like the garage, if I'm tearing down my garage and building a new garage, the garages don't tend to be, fall in line with setbacks. So how does that come into play when we're looking at, someone's coming to us and they want a variance because they're on a downtown property where, when it was built, it was before those setbacks were in play, and that's how everybody else along the street is. How does that come into play? Is that part of the uniqueness part, because of that particular property being located in an area surrounded by all these other properties? Is that how that comes into play?
And it could. And I try to stress this a lot. When we look at a zoning ordinance, you just can't look at one section or one paragraph. You have to take the whole zoning ordinance, every aspect of it, because there are other sections that then merge with or are related to other sections of the ordinance. So again, you just can't take one element. In this case, something like that would be a non-conforming structure. So a non-conforming structure doesn't meet the requirements of the setback, was established legally at some point. So it can always be used for that residence or the uses in the district, even though it doesn't meet setbacks, because the structure is considered legally non-conforming. If it burns down, because it has a non-conforming status, if an ordinance allows for it, you can rebuild on that same footprint and replace that structure. Again, it's all case by case by each zoning ordinance. We would allow for you to replace that as it originally was, and the setbacks that it was at that time, not having to meet current setbacks because of the non-conforming status.
Well, what about Mark, what about a situation, let's say I had a lot where there was never a garage there, You know what I mean? That there was never a garage. And now I'm building a garage, and if I place my garage per the existing setbacks because I'm in an older community or downtown, it's going to look odd compared to everybody else. And I apply for a variance. Is that where you get to the uniqueness part of the property or the area that you're in? Because everybody else's garage is like within 0 to 5 feet of the alley. And if you would be meeting the current code, you'd be at 25 feet back from the alley, and you look like totally bizarre compared to all your neighbors.
And I think case by case, as Karen mentioned, I think that could be the argument that they're making. I don't want to get into nuances. Garages as an accessory structure can be 8 feet. There's other things in the ordinance. Again, when you look at the whole,
Okay.
the principal building meets a setback, accessory may not need to. But I think that would be the argument. I think going to Karen's statement, though, when we have cases like this, and this is why I've been trying to stress, I want to hear the reasoning as to why there's a uniqueness or what the issue is, because that leads me to go, maybe we need to update the ordinance. Maybe there are these older districts and older developments in the city that there should be some already built-in allowance or variance standard that would allow them to equally enjoy what somebody would enjoy in a newer development. And again, that's why I try to stress what is the reason, because that leads us to how do we see this happening, and will this continue to happen in this neighborhood? And we don't want to see variance after variance after variance for the same thing if we can otherwise bring it forward and amend the ordinance to correct an issue.
I got you. So you could use it as an opportunity to update your code to maybe have a downtown designation that would affect that area differently than what would be typically R7500. I get you.
Absolutely. Or depending on when the lot was created and built upon, it predates the ordinance, therefore should it take advantage of the original setbacks. But again, that's what I look for in these variances, and what are we doing that could be creating these variances, and how do we fix the ordinance to correct those? I don't like to see variances. I'd rather the code be fluid and able for everybody to enjoy their property equally. But every once in a while, there will be a variance that change the ordinance isn't going to address. It really would be a true variance that would justify the granting of the variance.
I got you. That's a valid point that at some point in time we need to. So hopefully somebody's keeping a list of these different things that are coming up, because there certainly is a valid reason to update our zoning ordinance.
And again, that's why I stressed, and Karen did last week, why to get that feedback from the Board of Zoning Appeals and from an applicant, a better understanding of that reasoning, other than because I want it. Why? What are the elements of the need for it? And statements from BZA and their reasoning. It certainly benefits staff as we look at amending the ordinance.
Gotcha. Okay.
I'm sorry, Karen, hopefully I didn't say anything out of place.
Oh, absolutely not. But I did want to ask you if you might address 164, 169, and how that factors into the board's consideration of the cases that come before it, which is that criteria for determination.
64 for 169.
So I'm sorry I put you on the spot.
Okay.
So it's the one that says, in the exercise of its responsibilities, the board studies the specific property involved as well as the neighborhood, and considers the testimony and everything that's submitted, and in making its determination whether the petition or appeal will adversely impact the health, safety, welfare, et cetera, or would be dangerous to the community, they can consider these 15 relevant factors. Orderly growth of the community, traffic conditions, conservation of property values, most appropriate use of land and structures, prior decisions of the court.
Quite honestly, unfortunately, this is, I think, one of the lacking things that I would like to look at the rules of procedure. It's a little unusual with the city that somebody submits an application, but there's no true standard as to what we accept with that application other than the application form itself.
I'm glad you brought that up.
Then we advertise for it. Then we get the next information, and that's really the information of who may be testifying and what their expertise is. There's really nothing that, even though we ask for it, nothing that's provided by the applicant. I would look at these list of 15 items, things that the applicant should be considering in their proposal and what they submit to the Board of Zoning Appeals as to why they should consider these things. I don't see it the board's responsibility to figure these 15 items out. I think it's the applicant's responsibility to demonstrate how they meet these items, and then the board could use that information in their consideration. I see that more in the applicant, but again, there's not a clear understanding of that. I would like better information in the front end. One, it helps out staff when we sit down with people, what other information you might want to do. We do try to help people through the process, what we think they should put together, what information might be needed. But there is no requirement of that.
Sometimes it is nice where we receive packages where, attorney, quite frankly, attorney's involved and they are, savvy enough to go through that list bullet by bullet, and it's incredibly beneficial.
I have a question on that list. As I read it, I kind of focus on the may consider. So from my point of view, if there's 4 or 5 or 6 bullets that or subparagraphs that they meet, to me, again, on a case-by-case basis, that may be sufficient for me to make a decision. But I guess in either Mark, or whomever's mind, do we have in your mind a minimum of these criteria that we ought to be considering, in order to make our decision?
I think the criteria, it's a little unusual to me. When I read those, I do not think they apply to a variance. When you read them, they're more use-based and impact of a use. It seems like they're more special exception standards. What the number of people residing or working in the immediate area concerned. That's typically a special exception request. What is the impact of this use? Orderly growth of a community, traffic conditions and facilities, the effect of peaceful enjoyment of people in their homes, conservation of property value. So again, Larry, I think you're right. When you look at them, few of them would be related to variance. Majority of them seem to be related to special exception. There really is no clear understanding of how they should be used when somebody submits. So again, that adds to that, I think, a little bit of a confusion when you have an applicant trying to come in and we're working with an applicant. And I agree with you. Do they have to meet all 15? Should they address all 15? Which ones are important to them? And we do, again, we try to work with them and we do try to highlight elements of what we think they should mention as part of a variance application or a special exception application that we think is necessary and important for the board to hear. But again,
I may be off topic here, but if we take those 15 and we're talking about a special exception, I'm asking the same question. Because it says may consider, is there any sense of, can we do 1? Can we do 2? I will say as a board member, I don't feel they didn't need to meet the criteria of all 15.
Or any, if it's a may consider, I would say there's no standard that they have to meet any of them. I view it more as a guide. I don't think it's necessarily something that is needed in the ordinance. I think that would be a good item or element to be provided with an application packet that you would have and provide an applicant of information that might be important or relevant. Again, it's a little, and Karen, I've never seen, I'm not used to seeing a list of 15 items that they may consider. Again, that's a little unusual to me.
Can I comment on that? I'm glad this came up too, because I was going to do the same thing that Larry did, and that is question the verbiage that opens it up immediately when you say may consider. And typically when we've had, let's say, a commercial case versus a private residence case, And typically there's a attorney involved. The attorney normally runs down this whole list, whether it applies or not, they run down the whole list. In a case of a personal residence, oftentimes there's not legal or attorney representation, and they skip right over it unless staff tries to encourage people to look at these and to comment on those that apply. So, I mean, I think that might be some common and in between ground to at least identify these areas to any applicant and say, address those that you feel apply to what you're requesting. And then we're kind of covered. But if we don't encourage people to do that, then, you know, they'll probably take the least pathway to make their application. And it has been uneven. I mean, I've been on this board since 2004, and I can say pretty much, I think, favorably, any attorney addresses all of them in a commercial case, and oftentimes, more often than not, individuals, personal property owners don't. Just as an observation.
And as I say, we sit down and we try to maybe not go over this list of 15 items because I don't want to be looked at as by us stating, hey, if you talk about 1, 5, 8, and 10, I don't want to give any impression that by doing that, therefore you should get approval. So we really don't look at the 15 items. We just talk about your standard things of what you want to look at if it's a variance or special exception. And you don't only look at the property, look at the surrounding community, what other impacts that this use might create or concerns, and what might be asked about this use by the Board of Zoning Appeals. Just try to give an idea. But again, I'm not a fan of the 15 items because again, I think it gives it's just unusual to me. And I'm sorry, the other thing that, again, because we don't have a really good, clear understanding of what we give an applicant and what's expected to be provided by an applicant. So we'll get an application, we'll get that simple, these are my people that are going to present to the BZA, and staff basically goes in blind, and we're writing a report of what we think the applicant might be looking at or our concerns. So then we get to the hearing, and then they go through these 15 items, and staff was never given the ability to comment on or be aware of these items. And, you know, it's we're then we're caught behind the 8 ball because that could be somewhat frustrating and difficult because, again, we want to help people, but it just the way the process works isn't that clear to me or consistent.
The one thing I was going to mention, just as a side note, but I feel like we're kind of working around the edges in some of the discussion. And Ed, you have been on this committee for a long, long time and have a lot of knowledge. And, you know, Karen, you used to be here as well. Carroll County is in the process of updating their zoning code. And it is an overwhelming task. And I won't bore you with all the particulars of it. Besides, at times I want to beat my head against the wall with it. But I kind of think a lot of good points are being brought up here. And one thing I would maybe really encourage the Board of Zoning Appeals and staff and the BZA attorney to do is at some point in time, you know, I think you need to break it down. Like trying to redo your zoning code all at once is so overwhelming and I think next to impossible, because you just get so overwhelmed with it. But the BZA's responsibilities are very kind of focused in a small section of the code. I think there's some very valid points that have been brought up here. And maybe at some point, you know, within the next year, we need to take a hard look and the BZA should work with staff and make a recommendation of, you know, a text amendment, Mark, right? To update the code.
Yeah.
Could we not do that as a BZA?
Well, just to kind of give you background, we have been directed by the Mayor and Common Council to start looking at the zoning ordinance. So our approach is exactly as you mentioned, Dan, to take an entire ordinance at one shot, can be very difficult. So what we're looking at, and this is off topic, sorry, Karen and everyone, but we're looking at the landscaping section, sign section, obviously sign section needs to be updated, and parking. So the primary elements that need to be updated that certainly help to for development as development comes through, that we're more up to date with our parking standards. We have a more clear and concise landscaping section. The sign ordinance needs to be updated. We want to hit those three first. Then we're going to come back and look at the individual districts. But with that, we can certainly look at the section out, Planning Commission section, Board of Zoning Appeals, those commission areas as its own separate entity too, that we would run and have stakeholder meetings and coordinate with people to fix that section as well. So we're breaking it up. As you mentioned, it makes life a little bit easier.
No, I definitely think that's wise it just makes it more manageable. And then also, I think sometimes it's just more effective because when you try to do everything at once, sometimes you might step into some unforeseen controversy that, for lack of a better way, throws out the baby with the bathwater. And so I think breaking it down in approaching things that way just strategically makes a lot more sense all the way around. And hopefully you will continue to have a mayor and common council that's very receptive to those changes. But I kind of feel like, Ed, I mean, there's a lot of good points that you have brought up, and Larry as well. Like, at some point in time, we just need to update the code.
Right. Well, I think Mark said, and we all kind of, I think, trust in the fact that he's tracking these cases and types of cases and the decisions and where things have maybe been a little bit bumpy or unclear, and we'll focus on those areas. And he's identified some. Anytime we get into a variance with a setback, and especially in a non-conforming use situation, those, because we are an older community in many respects, yet we're looking at future development. Those things are always going to pop up. So, I mean, I think the priorities are almost pretty much self-evident, and Mark's identified some. So, go for it.
Yeah, don't get me started in the non-conforming section. That's...
Yeah, I know. I just thought I'd throw it out there, though. Anybody else have any well, I shouldn't be asking that. Karen, you're in charge here at this point.
No, I just wanted to say the analysis, the two-step analysis we were going through a little bit ago, if you look at 4206 of the land use article, you'll see where that language appears with regard to unnecessary hardship and practical difficulty. And then the Trinity case, it was much more the same analysis that you saw in there about the board's review and the court's judgment and what they will do, and a further discussion on uniqueness. And I think we've really already touched on all that, and we don't need to go into that any further. But that's really about all I had with respect to my presentation this evening. I'm happy to answer any additional questions you may have, or I can turn it back over to staff.
I thought there was two good cases. I mean, I got into them, and the more you read, and especially in the analysis sections, it really brought to light, a lot of things that needed to be read again. So they were good choices.
I'm glad you enjoyed it.
And pretty relevant to cases we've had.
And when the state has those training sessions, and I'll keep sending you just in case you're interested. The better one is, especially for the Board of Zoning Appeals, the second day when they go over the legal discussion, because there may be recent cases that they'll discuss and bring up that would be relevant to the BZA. So, And in all honesty, I like the second day better. I like the legal discussion better than the planning discussion. So I try to keep an eye out on those things and if there's any new case law or new cases that happen in the state that would be important or relevant.
To that point, Mark, when you sent that last message giving a heads up about the upcoming session that they held, I could not have done the first day anyway. And I had a question about whether or not you can go and get the second day on your own, without having to, go through the whole process and, well, if you don't get the first part, you don't get certification, et cetera, just as you don't get sense of completion, but you can go get the second day by itself.
I believe so. I think they sent it to us. We can certainly forward that to you, a link for the meeting. I think Andrew would have gotten that because he did attend the meeting. But yeah, it's not for certification. I think Ed had asked, once you take it once, is there a time limit? And I couldn't find anything in state law that said after X number of years, you have to take it again. Once you take it once, you're certified. There's no need to take it again. I look at more for just an update every once in a while. And to me, that legal section is, again, it's always more fun and interesting.
And Mark, Maryland Department of Planning sent me all the slides. I can share them with the board if they would like.
Yay. Sure,
Yeah.
if at least it, gives us a sense of what's there.
Yeah, in case you're sitting at home for some reason and can't get out. I have no idea why, but then you're bored. But no, I do. I know. I'm joking. The legal one is always really good. I do have fun listening to that one.
Well, if it hasn't been obvious to some people, I'm a lawyer as well, so I love to read cases before I go to bed, of course. They put me to sleep.
Well, that second one, Judge Harold did a nice job with. I liked it.
Yeah, no, like I said, every time it's the planning and zoning one. Well, as you can imagine, that's what I've been doing. So it's just like listening to the same thing over and over again. The legal aspect one, though, I always learn something new every time I attend one of those.
All right, we'll look for the next one and try to catch that.
I guess we'll offer, I don't know, we did state if there's anything you want to talk about past cases or anything like that at all, we can certainly do that, but we said in a closed session, if you don't want to talk about anything in the past, and because I'm only a year in myself, so I don't know if there have been past cases or other issues that came up or discussions, but I'll leave that up to you guys if you want to discuss anything. Otherwise, I don't think staff has anything else to bring up.
Well, and if I could jump in, as I mentioned when we talked about the Open Meetings Act, you are always, in any case, if you have a question and feel like you need guidance on the application of the law or interpretation, you can always request to go into closed session to get advice and counsel.
Right. Yeah, I think everybody knows that, and we've been pretty good at that in the past. So, and even contacting you, at least from a process point of view ahead of time as well. So, and there, any questions about whether or not we should think about recusal or whatever. But
I have a question, if that's okay, and it's not really about this, but we got into a conversation at the end of the last hearing about how we want to approve it, when we want to approve it, either midway like we've done or at it. I mean, not that I want to extend the time, but I do think we want to have that conversation while there's not an applicant on the line so we can decide how to move forward. I think there's pros and cons to both, but I will leave that to the experts to start that conversation of what we should do with that.
And that's procedural. So ultimately, I'm just more used to all the other jurisdictions I've worked at. It's always come back to the following meeting. It one gives the ability, if somebody was against it or opposed it, to bring that issue up again. If somebody wants to reconsider their ruling or their vote, but it also brings it back to the public themselves. I like transparency and people knowing what's going on. So 1 month they see somebody get approval, or deny or whatever it may be, and then they don't see anything about it after that. What happens then? What is the decision? When we do it internally, it's never provided to the public. Generally speaking, it's just it's provided to the applicant and we have it and it goes into our file. But any interested party wouldn't get that decision. I just think it brings that back to a closure just for the general public as well. And I understand the timing. And the other thing too, it's pretty quick process for Board of Zoning Appeals. Typically, they submit an application. If they're not before the BZA that following month, it's the month after. It's not like Planning Commission where you could be in the review process for a year before you get before them. It's a rather fast process. And again, if that's understood in the process and the procedures themselves, it certainly helps out an applicant in their timeline, as well as staffs too, as we're going through, as they start planning their site plan submissions or what the next step for them might be.
Right.
I wasn't at the last meeting. Can someone bring me up to speed on what exactly the issue or the idea was?
It was just that the ruling happened, decision was made by the Board of Zoning Appeals, and then the question was, should the decision come back to the next meeting for approval and adoption or signature by the BZA itself? We ended that discussion with, due to, and this is exactly what Brenda's bringing up, is that we've always done it one way. Why change it now for this particular applicant? So we just process it as we always do and left it open for discussion. Is this something that we should be looking at changing the policy or how we do a decision?
Because, well, we make the decision at the meeting, but then we issue the written opinion. And you're saying to hold up on issuing the written opinion until we meet again as a BZA. The concern with that is that you're potentially waiting to issue the decision for another 30 days, where in theory, a lot of times we could be getting it out within 15 days, depending on how long it takes the attorney to write it up and how long it takes us to review it and approve it.
I think another issue connected with that, Dan, is that this board in particular doesn't necessarily meet every month. So we could, it could be 60 or 90 days if we don't have other hearings, unless we meet, specifically for that, to make that decision public, which I think in our discussion, Ed was of the opinion that that's what we would do. That we would just, meet to approve that decision, and that may be our only order of business for the evening.
But
I'm not
well,
sure.
why? I guess what I'm getting at, if the decision was really made at the meeting, and you're just issuing the written opinion, correct?
But the written decision is what's appealable.
The
So if the written decision happens without somebody against it being aware of when the decision happens, they're unaware of their timeline when it starts. By bringing it back to the BZA, it's clear that that decision is signed that night. The clock starts for their appeal of that decision.
Because they only have, how many days do they have to appeal? 30?
I think 30 days.
Yeah. I guess because we've always said it, Ed, we've always said it in the past that we just issue it.
Yeah.
Correct? Whenever it's ready.
Just like you said, as soon as our attorney would get it written up and get it out to the board would comment and give comments back to the attorney, and the attorney would revise whatever comments we had, if it was appropriate, or they're just typographical or contextual or whatever. And then it would come back basically to me to print and sign and get to the city, or send it to Andrew. Andrew would print it and we'd make arrangements where I'd go and sign it at city offices. So and it was to get it out and get it available as soon as possible. But I also, Mark, am I mistaken that once the decision is made, that's also announced on the city's website?
I don't think we announced the decisions made. I'm not even sure we put it on the city website. So no, that's my concern is that
I haven't looked at the website in a while, I'll confess to that, but
Yeah,
I thought they were being posted under our planning, under the BZA portion of the page of the website.
I think, I'll just interject here. I think that the way we do it now or have done it in the past is more beneficial to the people that are coming to us as for appeal, because then we're not our decision, because we're not holding it up artificially.
Right.
And also, I kind of think it's, you know, if all we're doing is meeting to sign a decision, and that can be done via email, I kind of feel like, why are we making our lives harder? I think that we should continue on doing it the way we're doing it, though I think Mark has a very valid point. I think that, you know, once that decision is issued in writing, whether it's through our website or something, there should be some sort of notification that the written decision has been issued. That way, if there are members of the public that have concern, you know, or following that case, they know it. You know what I mean? They can watch the website, because like if I were curious about a particular decision, I knew I could watch it, you know, see when it was issued with the website. So I think there might be a happy medium. I just have concerns that if we're waiting to the next meeting to officially sign it, then we're delaying the process. And I just don't like delaying the process if it can
Mark,
be.
can I ask for clarification of what you just said, and maybe I heard wrong? So just example, last one, he has a deck, he's building a deck, we said yes. If we wait until the next meeting to sign it and officially have the written approval, do they still have to wait another 30 days before they can break ground or whatever it is they need to do, because there's a 30-day window of appeal?
Correct.
technically, yes.
Okay, so we're not just extending it until our next meeting, we're extending it another
30 days.
homeowner or the business owner.
Good point.
Yeah, and I don't like that. I don't like that. I think Mark has a valid point about the you know, that there should be a way to be announced a written decision. But if I was waiting on a BZA decision, I'm going to wait those 30 days out to make sure I don't get appealed. You know, and then if we're holding it up, you know, by another couple of weeks, or what if, Lord forbid, we can't meet 1 month because of something, then we could be holding up that process even more. And I just don't feel right about that. I don't know how everybody else feels.
As a matter of fact, on that last case, that issue 2 was the permit that the city had to sign off on back to the county.
And we couldn't sign off on that permit until
Right.
the appeal period ended.
And if I might, I just want to, for clarification, it would be coming back before you for a vote to say that the decision embodies your decision accurately, reflects your factual basis and your reasons. So it's not just assign it. So if you choose to continue to do it the way you're doing it, that's one thing, but I want you to know why it would come back to you.
Well, no, Karen, you have a valid point. It should still come back for us to acknowledge that we took that action via the email. Correct? Like, that's what your point is. But,
Well, so let's take the last case. That was February. I don't have a calendar in front of me.
First Monday.
Right.
Whatever.
So that was
Second.
February 2nd.
Yep.
And then the board, I think we got your okay to it the week of the 15th, right?
Right. You did a great job of getting it done.
Well, thank you. And so that was 2 weeks afterwards. So to have approved it at the next meeting would have meant a delay of roughly 10 days for that particular one. I
Right.
mean,
yeah, but the
But
problem
there-
is we don't always meet every month. Historically, there's been some months that we haven't met. So that's, I
That was
Well-
my concern.
But we would have to meet.
Unfortunately, we'd
Right,
have to
exactly.
meet. We'd schedule, yeah, if that was the only thing on the agenda, that would be the only thing on the agenda would be that decision. I mean, there's other, okay, I'm just looking past determinations. I'm also concerned that, and again, this is why I think I pushed and Karen also made comment that stating exactly how you believe it meets those standards. I've noticed in the past that that hasn't been stated, but then it appears in the decision. And I was always a little concerned about that statements that weren't otherwise made at a hearing are appearing into a decision, and concerned that I think from an outside person, it would seem that there had been meetings occurring outside of that hearing to create that decision. And that's always worried me. My job is also here to protect, make sure the Board of Zoning Appeals is protected, going through the procedures, the decisions they make, because I certainly don't want to be appealed and have to go through that process. So again, I've always been that more transparent person that by bringing it back, it eliminates that aspect as well. But, and I agree with you, Dan, I don't want to hold up people. That's my other thing. But if somebody's given a clear direction of how the process is, I think that says a lot. Not having a standard time when a decision is made, and it usually takes 3 weeks. So
Well,
I think it's partly about how the rest of the board feels, because it will produce more meetings. So, I mean, that's up to the board, I guess. But.
Yeah, if I may, first of all, I guess I was speaking what Dan was, saying as well. We have gone sometimes 2 months, consecutive months without a hearing, which creates its own problems. But the other thing, a lot of my career, I was actually at the table trying to get boards of appeals and planning boards and stuff to get these kind of approvals, for, communications sites, telecommunication sites or rights of way or whatever. And, even a month delay just, to go through procedure can cost, hundreds of thousands of dollars. I have to say I was not a happy camper when procedurally we got put back, which unfortunately happened from time to time. But so it's one thing to say somebody's, delayed 30 days because they can't build their deck. But it's another thing if you have a, corporate client coming in here saying, hey, we're just sitting on it because that's the procedure we have.
Well, the point is, even if it's 2 weeks, sometimes in business that matters. It does.
Yeah,
it does. I'm dealing with a construction project that I got going on right now, and I have somebody that's moving from California, and they're going to be here April 15th. I need to have the place ready for them. Do you know what I mean? So like an extra 2 weeks, if my electrician suddenly calls me and says, hey, by the way, I can't be there, or, I know it's a different circumstance, but like, so that's what my concern is that time does matter. But I think Mark has a very valid point that I think 2 valid points. If we're going to continue to issue our decisions the way we do, which is basically we review it by email, and then we say, hey, everybody's good with it, or hey, this one correction here, at least that's how it's happened in the past when we made our decision, is twofold. At the next meeting, we might want to reaffirm the fact that we, approved via email the written decision and it's been issued, just as from an agenda standpoint of good practice from Karen's perspective. But also, I think from Mark's perspective, there should be some way that the public is informed that the written decision was issued. And whether that's through the website or some other manner, to me, it seems like the website, because then if I'm an interested party and I know that the written decision will be, released via the website, then I can watch the website for it if I'm interested, and then it's public.
And again, for what it's worth, but it kind of emphasizes my concerns. When I was with one of the telecommunications company, a 2-week delay in the decision could have cost us $10 million in federal tax credits. So,
Whoa.
it can be real money. So
Just
I
a
know it's not,
question.
pardon me?
Oh, no, I'm sorry. I didn't mean to interrupt you. Go ahead.
No, I'm done.
I was just wondering a procedural question. Can minutes be approved by email?
I wouldn't.
Okay. I didn't know.
Yeah.
So I just wanted to ask.
You mean the minutes of a previous meeting?
Well, no, I'm sorry, like a written decision. Can I, Dan, I believe you were saying if, through email or something. I just wanted to make sure that I understood.
Well,
if
that's
whether or
how
not-
we've been doing it, is we've been approving the written decision, via
Oh,
email.
okay.
That's how we've been doing it. I mean, the attorney sends it to all the board members at the same time. And we quickly, look at that and provide back any corrections or whatever, and changes are made, and then a final is put out.
Yeah, because
And
the
if
decision's
I could
already
also
been made
art-
at the meeting. The decision's been made, it's just putting it in written form. Correct me if I'm wrong, Karen, from a legal standpoint.
Right, the decision was made, but it's the written decision from which an appeal may be made.
Yeah.
It's not the oral articulation at the meeting.
Right. I just wanted a
So,
clarification from my own perspective. I just didn't know if you can
Yeah.
approve anything in an email. I'm sorry, I'm
So-
not used to the meeting setting, so I just wanted to ask.
so I do want to make clear that although the draft decision is sent to the board members, there is no meeting, if you will, because each responds individually.
Individually.
So it's not a collective response. So I sent it out, I got information back individually. I made changes that were requested. And then when we had consensus on the changes were good, we sent the decision out to staff.
It's not really a discussion. It's more like reviewing to make sure that, Karen, you didn't miss something, or there's a typo, or hey, what about this? And you're controlling that process. It's not we're not.
Or take some liberty and put in my own views, or,
Yes.
No, I appreciate the clarification. I'm sorry. I just wanted to ask.
And the other concern I have, again, I have a lot of concerns, but I'll do, if you want to follow the process as it is, that's fine. I think there's other things we could do. Maybe at the time the decision's made, it is clearly stated that the decision will be provided. If you want a copy, please contact staff, and it will be placed online. So at least people are being told, this is where you go when a decision is made. It takes typically 3 weeks, 2 to 3 weeks. So that's something we could do internally. The other concern I always have too is anytime somebody wants or asks for what's that called when you're asking for information from a city?
Public Information Act.
Public Information Act, thank you.
Yeah.
And that's always a concern because we had a lot of these in Loudoun County, unfortunately. And then it also goes to emails that I again, protecting the Board of Zoning Appeals, it always concerns me that if you're using your private email for these communications back and forth, and I guess they could be argued to be client privilege because you're with Karen, that always worries me too, through email discussions.
Well,
Well, I
Mark,
think it would be client privilege, would it not be, Karen?
I would say yes, because we are communicating with respect to the contents of a draft decision that's not been made final yet.
Mark, wouldn't another option be, since the whole hearing has been recorded, that recording is made available for anybody who wants to listen to it and hear the decision? I mean, you
We
can.
do that. We do that. We put the recording out. But again, like I said, a lot of times decisions include more information than what is typically stated at the meeting itself. And so it should, it may not, it provides sections and, specific ordinance related comments that are necessary, but aren't typically stated at the hearing. But no, again, I think a lot of that could be just us staff and also the Board of Zoning Appeals, the members themselves, just clarifying when that decision is made that it will be provided. We'll put it on a link if you want copies of it. Anybody, also, I think we could do too, anybody that wasn't interested party and provided us with their email address, we could also forward them the decision as well. So we're covering our bases there too. So there's a lot of things we could do internally as well. So whichever way you want to go, it just dictates what we would do internally.
Well, how about can we do this? And I don't know if it's my place to recommend this, but it's a kind of open discussion. Why don't you put together what you believe staff can do, would be willing to do, and whatever we need to do as a board to comment back on that. And then let's try to make a decision. And does it have to be a public decision, or it can just be made internally, if you will? I think it can be made internally to say, here's what we're going to do about making this information available in a more timely way. And however you put that out.
Yeah, I mean, if the decision of the board tonight is that we want to keep how things have been going and it's working, then certainly we'll come up with comments and how we would address that going forward. We can certainly do that.
Other
In
board
that
members,
case, I would prefer we keep it as is
Okay.
with your
Yes.
clarifications.
Brenda, are you in agreement? That's kind of how I feel as
Yeah,
well.
No, I do. I think I agree that we probably should put it out there and make it that we have done the written, and it's 30 days from there, somewhere on our website or Facebook or whatever that looks like. But I'm hesitant to make people wait any longer than they already have to.
Yeah,
I'm in line for all of that as well,
Yeah.
to do it.
But I think that there's some good points that both Karen and Mark have made, and I think we can keep up with getting it out as quickly as possible, but maybe refine things a little bit to kind of address some of the concerns in the other direction. So
Typically in the past too, what we've done, and I don't know this, I don't want to elongate this, but at the end of the decision and before we adjourn, we typically have advised the applicant that we will have a decision prepared within X number of days or weeks, depending on the complexity of the case too. And Karen, you're going to weigh in on that one in terms of, so I mean, I think the deference should be to your ability to get it written to start with. I mean, what would be your comments there?
Well, most decisions can be written fairly quickly. You had indicated that 2 weeks was pretty much the turnaround time. So that's what I aimed for in the last decision. I mean, if it needs to be quicker, I mean, we can work on that as well.
I think
Also,
2 weeks.
will depend if you have six items in one night, it might be a little hard to get 6 decisions written in 2 weeks, but
Yeah, and that's another thing where we, to Larry's point, where we might have missed a month, but at the same time, we've had a couple of 3 occasions at least in my tenure where we've had more than one case. And Dan, you'll remember this in the case we had that went for 3 different sessions.
Yes, well, Karen, you remember that one as well.
Yeah, Karen was there for that one too.
So
I mean, I think we defer to you, Karen, in terms of that, and just make the best possible choice in terms of the complexity of things, in all due fairness, because of the legal aspect on the back end of any appeal. And it's going to go with the written decision.
well, and I tried to keep the format of the decision the same as you're used to seeing.
Yes.
But I might change it just a little bit here and there in the future, depending upon the nature of the case.
I think that's fine. And what needs to be captured needs to be captured. And And I wouldn't get tied up on the current format from my perspective.
Okay, thank you.
No, and Karen, again, I think 2 weeks is more than reasonable. I don't think a business person should be flipping out because it's going to take 2 weeks to produce the written decision. So I think that's a good goal, but I think you should feel free. Like if we have 3 cases or we have a case that's really complicated, you just need to be able to speak out if like, might need might need an extra week, this one, if it's a truly
Right.
complicated one, or you're simply overwhelmed. It is what it is. We just don't want to unnecessarily delay things any more than we have to.
Well, and I do commend the board. Each of you, the board members, got back very quickly. So thank you all for that.
Oh, yeah, that's what we signed up for.
I'm usually the slacker, so I'm the one that usually has to be bugged.
Don't beat yourself up, Brenda.
Because I'm the alternate, I hardly get to see them, so it's fun for me.
Is there anything else?
None from me, Mr.
No.
Chair.
Well, I think it's been a really good discussion. I want to thank everybody. Enjoy the remaining few hours of St. Patty's Day. We are officially adjourned.